why he did what the Attorney General has proved. So now the court went to investigate who had the burden of proving that the allegation that authorization was not given. Now, here are the facts. Dr. Paulson wrote a letter to the Bank of Ghana asking them to issue the letter of credit in respect of the transaction. And he signed the letter for, so you know how you sign a letter right for, which means that you are writing it on behalf of me, you are signing the letter on behalf of another person. So he wrote for the Minister of Finance, which is Mr. Tepe, and copied Mr. Tepe in it. You see. So if you say he had no authority, because on the face of the letter, he showed that he had authority, because he said he wrote it for, and then copied the person he wrote it for. And the person has never come back to say that, well, he wrote the letter without my consent. So if you say he did it without authority, you have to prove how he didn't get authority or that he didn't get authority in doing it. But it appears the High Court judge looked at it this way, that it is Dr. Paulson who has the burden of proving that he had authority. So the question is it the AG who proved that he didn't have authority, or is the accused person who proved that he has authority? The Court of Appeal was of the view that since in criminal matter, it is the prosecution is supposed to prove what they are alleging and prove it, in this case, it's the Attorney General who was supposed to prove that the authorization was not given. And it was easy, but the court went further that it was easy for the Attorney General to prove that because the material witness on this issue is Mr. Tepe. And Mr. Tepe, as we know, is still alive and could be compelled, even if he refuses to testify, he could be compelled by the court to come and testify. So the court was wondering why the Attorney General failed to call such a material witness. And there's a long line of legal authorities, case law, which says that when you have a material witness and you fail to call that material witness to testify, chances are that you will lose the case. Because if you leave the material evidence open, no court is going to help you to prove that. So the judges held again on the second point of authorization that the AG did not meet the essential element of the allegation he made, which is the evidence of lack of authorization. Okay. And the third issue, which was on Mr. Japa's rule. In other words, how did Mr. Japa, if you say he's also caused financial loss, then you need to show how he caused it. So the court began the analysis by looking at the contract itself and the parties to the contract. Then they found out that on the record, Mr. Japa was not a party to any of the contracts involved. There were two main contracts. The first one was that which was signed for the supply of the ambulance, I think in 2012. Then in 2016, when the breaches were identified, there was another meeting between the Ministry of Health and the Big C, that's the suppliers of the ambulance. And in that meeting, they agreed for a new roadmap to remedy the defect. And in the remedy of the defect, the agreement was that the Big C, that's the suppliers of the equipment in the ambulance, would ship those equipment that were not brought, and that the government of Ghana had the responsibility of clearing those things from the port and then fixing them to the ambulances. So new obligations were created, which is that one, Big C would ship the equipment and the government of Ghana would clear them. The record shows that Big C, that's the suppliers of the ambulance, did ship the equipment, but that the government of Ghana either failed or refused to clear the things from the port. So then the court asked, with this development, how can we see that Mr. Japa, who is presently before the court, was the one who caused any loss? First of all, he was not a party to the contract. The contract was between Ministry of Health and Big C. Japa is not a director of Big C. He was only an agent for Big C. And the position of the law is that when you are an agent for someone, unless there's evidence that you did something which your principal has no authorization to do, it is the principal who will be held liable. Or if anything at all, both the principal and his agents would have to be held liable. In this particular case, the court saw that it was only the agent who was brought and that no one from Big C was before the court for trial. And since Mr. Japa did not have any role to play in any of these transactions, the court did not find him to have been involved in any cause of financial loss. And simply that the fact that he is an agent does not mean that he's automatically responsible for losses that may have been caused by his principal. So by way of summary, if you look at what the judgment of the majority, you would notice that what they are trying to communicate is that the Attorney General brought persons to be prosecuted who were not the people to be brought. In other words, there are other people who were more, implicated and could be more, and the court used the word logically connected to the law than the people who were brought before the court. So, for example, when it comes to the payment issue, it was the Ministry of Health which was the primary, ministry dealing with the ambulances. And so if the ambulances were negotiated and brought without, and there were losses, the court seemed, from the judgment, it appears to me that the court was indirectly saying that you could have brought at least someone from the Ministry of Health as an accused person, and no such person was brought. Then, in terms of the authorization, if you think that something was done untoward, is the ultimate person who is the Minister for Finance himself, not his deputy, because the deputy said I was authorized by the minister. And so you should have brought the ultimate person, the person who was either as a witness to deny that he did not authorize, or even as an accused person to say that, well, he did authorize, therefore the fact stopped, with him. And when it comes to Mr. Jakwa's side, you realize that the court was indirectly saying that, well, this person you have brought to us, you've not provided any evidence of how he contributed to the loss. He is an agent. There's a principal who was on the other side. So where is this principal? So that is the lack of connection between the accused persons brought to the court and the transaction involved was the common thread that ran through all the judgments or all the opinions of the judges in the case. In other words, the fact that there is a loss doesn't mean that you can just go and carry anyone and say you are the one who caused the loss. There's something in law called causation. Causation is who actually caused it, and there must be a logical connection between the harm that you allege to have been caused and also the persons who caused the harm. So the fact that someone has died doesn't mean that you can go and bring anybody and say he was the one who killed the person. So it is a question of lack of connectivity between the alleged crime and the persons who caused it. And this goes in a way to support and secondly, there was also no evidence. There was no evidence of record which actually detailed how the losses were caused, because or that there was even a loss caused, because if you enter into an agreement and you renegotiated after some defects were found, that renegotiation should suggest that both of you have reconsidered your options and have decided to review and take steps to remedy it. And when the steps were taken, the government had an obligation which it failed to perform, which is to clear the things from the port and fix the ambulance. But that was not done. So then the question is, if there was a loss, it couldn't have been people who negotiated and did all that. It could be someone who refused, to fix, to perform the other part of the contract. And you will see that 2016 was when the renegotiation was done. And by 2017, when the things came, I think government had changed. And so it is the government of Ghana continuing in 2017 which failed to do the clearing.
Having said that, the Attorney General in interviews granted after the judgment was delivered points to the fact that Mr. Jakpa was actually, there were payments of about 700,000 euros paid to Mr. Jakpa. He thinks that this is an enough link to link Mr. Jakpa to the contract. What
Yeah,
do you think about that?
The court looked at that and said that if you're an agent, you work for commission. Okay. So it's like, let's say you have a house and you're renting, and I'm your agent in looking for a tenant. When the tenant comes and pays you your rent, I'm entitled to my commission. Okay. If I receive my commission, it doesn't mean that I've caused any loss to anyone, because I have worked, I've negotiated with the person, they've agreed on how much I'm supposed to get. I have worked for it, I've done my part of the deal, they have paid me. That is a completely different contract from the rent between you and the tenant, the landlord and the tenant. And so the court was of the view that is no evidence. The fact that the man has been paid his commission for the work done, there is no evidence that it had anything to do with or he caused any financial loss to anyone. And in fact, the court said the fact, and I think at the point, Mr. Jakpa sued Big C for the money. So the Attorney General was trying to rely on that suit, that if he sued, it means that he had a role to play in the payment of the money. But the court said there's a difference between someone working for his commission and getting his commission, and another person promising to supply goods of a certain quality and failing to supply that quality. So there's no real connection again between the money he received for his work done, for his lawful work done, and the contract that is in issue at the moment.
The Attorney General says, describe it, I think it's as a perversion of justice that he will head to the Supreme Court. Good decision?
First, let me just address the words, the comments, and the words that the Attorney General used. You see, I'm sure we've all been in this country. We've seen people being dragged, lawyers being, dragged to court, and even non-lawyers being dragged to court for contempt because they have used their choice of words seek to expose the court to public ridicule, hatred. I understand how it feels to lose a case, and a very important case like this. And I know if you have done a lot of work and you don't get your outcome, you would be very angry and sometimes very sad and disappointed, even in the judgment and the legal system as a whole. But that is exactly that's what it is. But that should not translate into using words as perverse, inimical, to create an impression that the judges were not interested in fighting corruption, and that they are helping corrupt people to get off the hook. We have seen that before, where people have said that about judgment, and that this particular Attorney General would mount platform to name call those people who have critiqued or have used even less harsh words on the courts. I remember a couple of just a few years ago at the bar conference, the Attorney General was the one championing a call on lawyers not to, and he was very specific. What we got NDC lawyers for not for using some words and saying things about the judges who rule on cases. So I was particularly surprised that he would turn around and do the same thing. And I think that if he should take a second look and consider, probably retracting those harsh words. You could definitely criticize the court, but those words and the circumstances under which he used them were not the best that he himself would be proud of. And I wish he would take an opportunity to remedy that situation, either by retracting or showing some level of remorse. So, because he would have said words and probably even begin dragging other lawyers to court for contempt if they said those things about judgments that did not go in their favor. So that is what I would say about the words. Now about the decision to appeal. Obviously.
Now, before you go to the decision to appeal, this is Alfred Tuah, who is Deputy Attorney General, speaking. Quote, if we had filed an appeal and in it one of the grounds indicated that the judgment is perverse and cannot be supported by the evidence on record, would that be wrong? If you say a judgment is erroneous or illogical and lacks ground for and lacks ground for appeal, would that also be wrong? With all due respect, the AG statement is a normal statement. How do you respond to this?
Oh, okay. So you see, he's not taking the words in context. If you say something like there's a bit of hold on. It says it's perverse in the quest. You see, he's just taking the word perverse out of context. This is what the statement said. It says the office of the Attorney General considered the decision of the Court of Appeal to be perverse in the quest for public accountability and rule of law. So you are not saying that the judgment is perverse by itself and standing alone. You are saying that it's perverse in the quest for what? Accountability. What you are basically saying by this full statement is that the court is refusing to hold people accountable. That has nothing to do with the reasoning of the judge. It is a political statement that people have committed wrong and the judges have jumped to the defense of those people when they should have been helping you to hold them accountable. So if he's not picking the word, he's not using the word, his explanation does not address the context within which, the full context within which the words were used. If you say it is something is inimical, I mean inimical to the fight. So this is what he said. He said the paragraph 4, he says the office of the Attorney General considers the decision of the Court of Appeal grossly unfair to the nation and inimical to the fight against impunity and abuse of public office. When you say judgment is inimical to the fight against corruption and abuse of office, what you are basically saying that the court is promoting abuse of power, lack of rule of law, and all the wrong things that we all are fighting against. So, and that cannot be supported. You cannot accuse a court or a court for doing this unless you are taking the court out of the legal framework into what? To politics. You remember when the special prosecutor said a similar thing about the courts? You remember the famous press conference where he said that he's a bed and his time will come and he will go, and that the courts are frustrating his work. What did these attorney generals say about it? They thought they were courageous enough to say that no, you cannot be talking like that. You cannot call the court. If you lose the judgment, you just address the issues in the judgment. So there's nothing in the judgment which talks about rule of law. There's nothing in the judgment which talks about the fight against impunity. There's nothing in the judgment which talks about abuse of public office. There is nothing in the judgment which talks about public accountability and rule of law. So if you are using words like perverse to bring those things in, those are political statements which cannot find space in any of the judgments that I have read. So I personally think that the words were not the words should come from Attorney General, especially a person who has always complained about people's words against courts.
Having said that, then a decision to go to the Supreme Court. What do you think?
Well, I as a lawyer, I know that the first reaction of every lawyer when a decision did not go in his favor is to think of filing an appeal. That is the first thing that we all think of. I would have to appeal. But then again, at the time they said they would appeal, I believe they've not had the privilege of reading the judgment and reading it thoroughly. Because when you are going to appeal, you have to read the judgment thoroughly and pick out the points of error, whether in law or fact, and all that. And that was not done before they made that statement. So I can understand the pressure and the disappointment which caused them to do that. But having had the judgment to read and having looked at it, I think they would probably reconsider their decision. And even if they would still appeal, I believe strongly that their appeal, the appeal that they want to appeal would not be in the spirit of the statement they issued. Now, why would I appeal? You see, this case has suffered such a lot of, like, the Attorney General has been battered severely in this particular case. And the things on record are things that, to be honest with you, you shouldn't have in any legal system happening. And this brings the question, if the Attorney General was very confident of his case, as he was trying to say, you ask yourself, if you are this confident, then what business do you have talking to the accused person, one of the accused persons on phone, and trying to cut him into giving evidence which would help your case? So clearly there's lack of candor, lack of genuineness in the claim that the Attorney General claimed that his evidence is so solid and cogent. If the evidence you have on record is cogent, and remember, those conversations with Mr. Japa began after the High Court dismissed Mr. Japa's submission of no case. So what it tells you is that even as at the time the submission of no case was dismissed, the AG knew that his case was not solid. And that was the only reason why he would be speaking with Mr. Japa to give him some level of support during his defense. So if we know of all this, and these are on record, these are things on record and the record of the court, with all this audio conversation you had with him, why are you now pretending to be shocked that your case was not solid? And name calling judges and appealing. This is what I think of when I think of the fact that the Attorney General wants to appeal. And so this is not something that, and even for his own reputation and integrity, at a point, you need to let sleeping dogs lie. Because personally, this is what I always think. Would a court, having regard all these facts, all these attempt to court witnesses, and all these allegations, look at what happened 2 days ago with the chief of defense staff, coming to contradict your own witness, coming to contradict your interpretation of a letter and all that. These things, would the court look at all these things and say that even if the people did cause financial loss, they will say that the process is fair enough to support a conviction or deny someone of their liberty? So he has made so much mistakes, he has made so much, wrong moves in this case. And in as much as we would like to prove that at the end of the day he got what he wanted by whichever means, it is also important for him to consider where he stands as the Minister of Justice, as Attorney General, as someone who is supposed to bring confidence and integrity to the legal system and the justice system. He needs to consider that and advise himself on the next move that he wants to make.
Very interesting. And let me conclude with you on this. There are many who have questioned his judgment over the period of this whole trial. How he's handled every end of the process, including when that tape came up and everything. Are you one of those who thinks that the Attorney General's judgment has been particularly troubling over this whole case?
Oh yes, his judgment over the case, his conduct over this case is I think one of the most bizarre that I've seen in my years of practice. Have you ever seen something where we are not talking of a state prosecutor saying, calling a witness. We are not talking of chief state attorney. We are not talking of principal state attorney. We are talking of the Attorney General himself. Nicodemously talking to a witness, at a point even telling the witness to go and lie to a court that he will be sick and that he cannot make it to court, so that the Attorney General can travel and come back. How bad can it get? You see, I don't even care what the details of their conversation is about. But the rule is, you should not communicate with an accused person who has a lawyer in the absence of that lawyer. That is the rule. And the rule doesn't even don't talk about, it doesn't prevent you from, it's not about what you see, it's about the move, the very move that you are even talking to the person. I always use this example. In exam situation, because I'm a lecturer, so I use what I'm familiar with. In exam situation, the rule is that don't bring foreign materials to the exam room, okay? And another rule is that don't communicate with another candidate in the room. So when we walk in and we see you with a foreign material, you have already breached the rule We are not now going to ask you whether what you have is geography or mathematics or has anything to do with the question that has been brought. That is not what the rule is seeking to address. The rule is that don't bring any foreign material. So when you bring a foreign material, even if it's a geography exam and we find a foreign material of what do we call it, dance or drama with you, you still break the rule. So the rule is that don't communicate with an accused person who has a lawyer without in the absence of the lawyer. So when you do that, the question will not be whether you were trying to court him, you were trying to have him, and in this case, the evidence will show that you were making efforts and attempt to have him, testify in a particular way to help and support your case. So clearly, I have never seen something like this before coming from the Attorney General himself. So this is enough for anyone to question the kind of practice that the Attorney General has put up in this particular case. And it is not something that we should be proud of as a country. It is not something that we should even entertain. But of course, we have entertained it, and I think this is a golden opportunity for him to let this matter go off his neck, and then he will have his own peace of mind.
Doc, always a pleasure talking to you. Thank you. Thank you for speaking to us.
Thank you very much, and have a great day.
You too, Doc. Dr. Justicce lectures at the Faculty of Law of the University of Ghana, speaking to us this morning. Always a pleasure talking to him. Breaks down issues so well for you. You understand exactly what the whole thing is about. And I guess if you listen to him, you get an idea, the basis for the court making the decision it's made. Don't worry, I'll come there. I'll come there.